Our next witness is Mark Sargent. Mr. Sargent.
It helps a lot of people. The numbers with the names, because people know their numbers.
Sure. Mr. Sargent, yes, you in fact are 49, followed by Michael Witowski. I think we determined Sonny Kelly is not here. Pamela Eisenlohr, Wilma Oscar, and then Alicia Mathers.
Alicia's not here either.
I don't have written testimony. Thank you very much for being here. I appreciate the sacrifice that each of you have made. My name is Mark Sargent. I'm a stay-at-home father. I have been for the last 7 years. I have sole legal custody and primary and basically sole physical custody of my 3 children.
Hold on, Mr. Sargent. I'm not sure why, but your mic doesn't seem to be working. Thank you. I'm sorry.
So, do I get to restart my 3 minutes?
Yes, your 3 minutes starts again.
I'm Mark Sargent. I'm a stay-at-home dad in Westport, Connecticut, where for the last 7 years I've been a stay-at-home father to my 3 children, who are ages 11, 9, and 7. I have sole legal custody of my 3 children. They live with me. My ex sees them in certain limited circumstances. And when you're in my situation, one of the things that's really difficult is figuring out exactly what to do. So I appreciate all of the people who have mental health backgrounds, and they struggle with the same thing I struggle with every day. And so I am kind of, I think, uniquely situated to comment on some of these issues. Before I was a stay-at-home dad, I am a magna cum laude, Order of the Coif, graduate of the University of Pennsylvania Law School. I practiced law in New York. When I graduated, right out of law school, I clerked for a federal judge while I was working on a doctoral dissertation in economics, which I ended up not finishing to go on to Wall Street. Had a good career before I decided to be a stay-at-home father. So the big picture, I have a background as a father, I have a background as a lawyer, I have a background working for the judiciary, and I am a pretty serious student of the impact of legal rules on economic incentives for profit-maximizing individuals. And I think, the economist in me looks at this GAL system and says this is exactly what you would have expected if you allow private individuals, some of whom are going to be rational profit-maximizing actors, to collect money with government compunction. And that's really what this is about. Whether you call that person who has that power a guardian ad litem, a court-appointed attorney for the minor children, whatever, anytime some private profit-maximizing individual is permitted to collect money at government compunction, where people who don't pay that money can lose access to their children, can be imprisoned, can be fined, have all kinds of bad things happen to them, bad things are going to happen. So this is completely predictable. And to kind of cut to the chase, my end proposal is the elimination of the entire private pay guardian ad litem system, and I think it's bad for a lot of reasons. My one big claim to fame is I believe I am the only person in Connecticut history, I'm the only divorce litigant in Connecticut history who has ever gotten his guardian ad litem for his minor children removed for cause. I think I'm it. I can give you lots of reasons why you should not even try it, okay? I can give you a lot of reasons why I'm the only one. If you really want it, I could tell you the whole story and talk to you about how irrational it is to even try and have your GAL removed. You're basically kind of crazy. In Connecticut, as a legal matter, divorce litigants do not have standing to file a motion requesting the removal of their guardian ad litem. That's shocking to people, right? How can it be that, I think when I watched some of the testimony earlier, some of the earlier sessions on television, someone suggested you can ask for your GAL to be removed. Well, you can file a motion for anything you want, but when I did that with Norm Pattis, who's a civil rights lawyer, some distinction, the response to that motion was a motion to dismiss my motion to dismiss the GAL because I had no legal standing to bring my motion. And in fact, that's legally correct, and the opposing counsel had a series of court cases that supported her view. Okay? So as a practical matter, divorce litigants have no standing to ask for the removal of their GAL. You don't. In my case...
And I'm going to need to ask you to summarize, if you may.
Okay. In my case, I was subject to significant retribution for attempting to remove my GAL. The only reason it was even possibly rational for me to do this was because I didn't think she could take the children away from me, given some unique circumstances about the alternatives. I admittedly did not anticipate what happened when she threatened effectively to put my children in foster care. But at the end of the day, I didn't think that was going to happen, and my goal was that if it was going to happen, I was going to make sure it happened on 60 Minutes. That's sad. I have spent more than about $130,000 in fees for my GAL, and by the way, I don't get that back. When you get rid of your GAL, what you get is the right to pay someone else to learn what happened for the last 3 years. I think that the lawyer, since when I made allegations about my GAL, instead of investigating, the court appointed an attorney for her, not an attorney for the minor children, an attorney for her. That person who showed up in court announcing that his standard billing rate was $850 an hour, then immediately in his first appearance got the judge to issue an order that I not have any contact with the GAL or be physically present with her except through him. So let's step back and do the math. Let's say I'm paying my lawyer $600 an hour. I'm paying the GAL $300. I'm paying the GAL's lawyer $850, which is what his initial ask was. Later he cut it back down to $600. I haven't written him a check for any of the $20 or $30 or however many $1,000 he thinks I owe him. So basically, in order for me to contact the person who's protecting the best interests of my children, it would have cost me something like $1,000 to $1,200 per hour. Why is this particularly crazy? I said at the beginning, this is a post-judgment action. I have sole legal custody of my children. They live with me. They spend every night with me. I'm the only person who knows anything about them. Okay? So it's completely ridiculous that in response to allegations that I've made against my GAL, a lawyer is appointed for that person. That lawyer shows up and announces, and the transcript is great and to the point, and I think I'll submit the pages, that he doesn't want to say a reason, but he would like the court to issue an order that I not have any contact with the GAL except through him. The judge says, okay. I had already previously, since I'm kind of a civil rights gadfly, I actually care about constitutional rights. I previously sued with Attorney Pattis, Judge Emmons in the Stamford Family Court. I sued her because she kept having status conferences, and the 3 years has gone on. I've had exactly one hearing, I think, and that was the hearing to remove my guardian ad litem. What really happens in the family courts is you get status conference after status conference where your parenting rights are altered without notice, without a hearing, without admissible evidence, and I was not okay with that. And so I sued for declaratory and...
I do need you to sort of come to some sort of...
Big picture-wise, the whole thing doesn't work. This is a completely expected outcome to allowing private profit maximizing individuals to collect money from families in very difficult circumstances at government compunction. There's not going to be any way you can reform this. You can't regulate this. You have to take that away. You have to eliminate, in my mind, the entire GAL system. The most impressive person who testified for me was the guy this morning who said he got divorced in 1990-something, and there were no GALs. There were no GALs. I think, absent a circumstance where both parents have been determined unable to parent, the best interests of the children should be represented by the parents. We shouldn't have this incentive where instead of agreeing with your ex, you have an incentive to just outvote your ex 2-1 with someone who has the ability to get money from families in difficult circumstances, who is absolutely unaccountable to anyone. And that's true, okay? Because, again, even my guardian ad litem, who was dismissed for cause, gets to keep the money. She gets to keep the money. She has immunity still. Doesn't take away the immunity. This is not a good system. I'm happy to discuss, there are good GALs, they do good things in certain circumstances, but as a system, it can't work. It can't work. So I think that the appointment of a guardian ad litem on behalf of minor children should be limited strictly to the circumstances where both parents have been determined unable to parent the children in a hearing with due process, and in every other circumstances, the best interest of the children should be represented by their parents. And what we should do is give the parents resources to help present those arguments to the judge.
Thank you. I would just note that there have in fact been GALs around since well before 1990, and indeed the no-fault divorce law, which passed in 1974, provided that a GAL should be appointed to children in every case, and that has since obviously been modified, but we've had GALs. I've served as a GAL here since well before 1990. But thank you for your testimony. Are there any questions for Mr. Sargent?
I have one. I just wondered what other recommendations you might make about the system other than just removing the GAL from the system.
Okay, I actually spent an enormous amount of time thinking about this just because I have an interest in public policy, and I really appreciate the mental health aspects to this, which are really quite complicated. One of the things I would do is I'm a big believer in terms of the parental alienation and step back. The first thing is you have a problem because the judges aren't enforcing the law. That's a huge problem, right? There's no accountability for the judges either. So even whatever legislation you guys come up with is actually irrelevant, even if it gets passed, if the judges don't enforce that. I think you've heard from a large number of people, and I can tell you from my personal experience, the judges don't enforce the law. So we need much more accountability for the judges. We start with that, and I think there needs to be some kind of peer review system, some evaluation. If all of these complaints about judges are getting dismissed year after year, there's a problem. You need to fix that. The second thing we need to do is, with respect to the attorneys, you have the same issue, okay? I think it probably makes sense to treat family law differently. In the United States, we have equal protection, and that means that people get treated equally, but it also means people that are differently situated get treated differently. Family law litigants are differently situated. They're in extremely difficult circumstances. I think you take all of the lawyers, all of the judges, and everybody who gets an appointment for a family law position from a judge, everyone who can get appointed by a judicial order, you take them all and put them into a supplemental mental ethics review system. So basically, if I'm a family law litigant, I shouldn't have to figure out, do I want to make a complaint with the Department of Public Health, the bar grievance, whatever. There should be one group of individuals. I file the complaint with them. They're going to evaluate it. It shouldn't consist of anybody on any industry. It should be funded by, I would fund it with a head tax. I would charge a tax initially maybe of $10,000 a year on every single person who receives any kind of judicial appointment at all, full stop, period. And then I would give people refunds if after 5 years they've had no complaints, okay, that kind of thing. So you need to put much more accountability back into the system. I would have mandatory fee shifting for circumstances where people have violated orders. And a lot of what people talk about as parental alienation really is that in addition to having judges who don't follow the law, you have judges who don't enforce orders. You do. You have people who've got the order. They're entitled to see their kid. The kid's supposed to be delivered to their doorstep. The kid's not there. That doesn't require legislation. That requires a judge to stand up and do what's right. Part of what would help is if you had, in any case where a person has denied the other parent access to their children, there should be an accelerated process where you can get in extremely quickly, because I think the consequences of that are really severe. Full disclosure, on one circumstance, I denied my ex access to that, okay? I would be okay eating the cost, whatever the penalty is, when it really is one of those emergency circumstances, because as scary as it is to be without your children, I've picked up my children at the hospital. That's bad too, okay? So I could do that. What's funny to me, not funny, but one of the things that's interesting to me, I have a background in cross-border finance and tax law. There are a lot of tax laws where I don't know what the right statutory solution is. Here, I actually kind of think I do. I think I could come up with a statute that would solve a lot of these problems. I would have a lot more accountability. I would have mandatory fee shifting in the case where someone has violated an order. In a case where a parent has been denied access to a children, I would put those first in the case. One thing I've thought about, and this is the craziest idea, and I'm not a big fan of the Scandinavian system or really crazy ideas because I don't think they're practical, but one thing I think may be practical is eliminate the family courts in Connecticut and just merge them into all of the superior courts. There'd be some benefits of doing that. One is, right now, it's too easy for a judge and a lawyer or GAL or all of the above to have a cozy relationship. If the pool of judges was much bigger, that gets to be much more difficult to maintain, and that's a big part of the current problem. Okay, because I'm really anti a lot of these conspiracy theories I hear, but there definitely is malfeasance within the courthouses. There is, and that's really sad. So that would solve some of that problem. The other thing that would happen is that there's a big lack of resources in the family court system, and that's part of why the judges are doing this, right? The reason the judges love GALs is they get to delegate the entire judicial process to a private individual. They're not going to be responsible for the decision. That's why they always accept the recommendations of the GAL, and then it becomes you have this GAL has an unreasonable amount of power, okay? So if you merge the family court system into the general superior court system, and you have only one court system, the cost of the family court system would basically get spread, it would impact, and what would really happen is all the commercial litigants would find out they suddenly can't get anything done, and they would come to Hartford, and I'm guessing they have a lot more pull than families in very difficult situations do. So I think that those situations would get addressed over a lengthy period of time. You also end up having a huge number of practice book provisions, and by the way, the practice book in Connecticut is unlike anything I as a lawyer have ever seen. You have a huge number of practice book provisions in Connecticut that are aimed specifically at family court operations that in large part are in some way tailored to dealing with the huge number of pro se litigants. I think that's bad, and since I've been a pro se litigant, I'm represented by Attorney Pattis now, I can't tell you how disrespectful the judges were to me. And again, I worked for a judge. I clerked for a judge. I went to law school. I did reasonably well there. I wasn't allowed to talk. Because the guardian ad litem would just talk and the judge didn't care. The judge would interrupt me and ask the guardian ad litem what to do. Okay? That's not okay. That's not the way it works. I think the guardian ad litem shouldn't be there. I think the kid's parents should be there. And the best interest of the child should be represented by the parents. I do appreciate for some parents that would be difficult. I think that if we took the resources that go into the GAL program and put it into empowering the parents, that would be better. And by the way, that changes the dynamic. Because right now, if you're a family court litigant, you don't have to get along with your other parent. Quite the opposite. You just have to get the GAL. And a lot of times you can do that just by hiring the right lawyer. And a lot of the lawyers advertise themselves on that basis. Okay, they do. They're like, I know your GAL, I know how to do it. You just pay the person money and, it'll work. And you will get your vote. And that's sad. But then what happens is the parents go and every single time they're in front of the judge, one parent is outvoted 2-1 because the GAL effectively has the tie-breaking vote in every decision. You take the GAL out, the parents have to get along with each other. I mean, you start having to negotiate with the other parent. That is a much better system. I think I appreciate there are good GALs. I understand there are reasons for them in certain circumstances, but I really think that they should be very, very, very limited. And I think in absolutely no circumstances should a private profit-maximizing individual be entitled to bill families in difficult situations at government compunction. That's not okay. That's inviting malfeasance. What you've ended up with is kind of predictable.
So in your own case, I'm hearing your suggestions about the parents should be the ones advocating for the kids' best interests. In your own case, would that have worked?
I think it would have worked better. And what's interesting, and I hear all these people say, except in cases of extreme mental illness. The difficulty of it is, when you start in the court, you don't know who the mentally ill person is. That's really, really hard. That's really, really hard. And with all due respect to the psychiatrist who testified a few people before me, if we had a special panel, if these personality disorder cases got into a special panel, that would be, how do you decide?
Right.
I mean, that's the entire point.
That was going to be my next question.
Sure,
which
that's
is
completely impractical.
Part of the process ultimately is trying to discern whether there's an issue there, and if so, what it is and how to address it.
In my case, I think it would have worked. Because in my case, I had the evidence I needed. If I had been permitted to put it on, I would have been able to make my case. The problem was I couldn't put it on. Why? Well, for one reason, the guardian ad litem had the privilege. Even though I have sole legal custody of my children, even though I have a provision in my separation agreement that I drafted, I was pro se at the time of my separation agreement was finalized. My wife had a guardian appointed for her. My children had a guardian appointed for them. My wife had a lawyer. I was pro se. I ended up with sole legal custody of my children, and I insisted upon and got a provision allowing me to make unilateral medical decisions. So I'm thinking that, whatever the kids' therapists are seeing, I can bring it to the court. No, I can't. Because even in those circumstances, the judge thinks, and I think there's a serious constitutional law issue there, so the lawyer in me will say, I don't think the judge is right, because there are these situations where custody hasn't been resolved yet, and you can't apply those to situations where I have sole legal custody as determined by a finalized divorce decree, right? But in general, you don't have the ability to bring a lot of evidence in. The evidence isn't going to be considered. I think if you empower the parents, the judges are going to be forced to listen to the parents. They're not going to be able to delegate everything to a GAL. So in my situation, it would have worked better. Yes.
I like what I heard you say about expediting hearings. I've been saying that on a number of occasions. I think when ex parte applications come in, there needs, I asked that gentleman before, did you have access schedule?
Yes.
You know, they can't just say, we're going to grant this, and, you know, it goes on and there's no access.
Yes.
And I think when someone withholds access, there should be an I think we should recommend an expedited procedure for that, because I in my own experience, I've seen it drag on forever and ever, and someone is not getting access, and we've heard time and time again, and we all know, then it becomes moot.
Okay, and that, again, I don't have any alienation issues. My wife would argue that the children have been alienated from her, okay, and I understand her view. I will tell you, though, the problem that you're going to have with that is you need to make sure you get the judges to buy in. Just to share with you what happened in my case with ex parte motions before December, after I got rid of my GAL, there was a brief period where I had no GAL. One of my children's therapists filed a DCF report because of concerns about one of my children and my ex. And I want to be very respectful of her privacy, but and that, so I used that as the basis of filing an ex parte motion. My matter had been moved from Stamford to New Haven, so we filed the ex parte motion in New Haven. The judge in New Haven said it had a docket number in Stamford. You have to go to Stamford. So, you know, the lawyer takes it there. The judge hears it, denies it, schedules it for hearing on Monday. We get to Stamford on Monday. I have deposed everybody at great expense, right, the kid's therapist. And on that Monday, the court says, you already have a status conference back in New Haven on Wednesday. Why don't you just go do it there? We get to Wednesday. The judge says this is just a status conference, and since I've actually sued a judge for changing parenting rights in status conferences, she was probably correctly reluctant to do that. And so I'm not making this up. One of my kids' therapists filed a DCF report. I use that as a basis of an emergency ex parte motion. I haven't been heard.
Right, and I guess when I talk about ex parte, like restraining orders, they're not because you're safeguarding your child in that instance. It's, you know, an allegation of domestic violence between adults, and that gets used to circumvent access. So,
Yes.
I mean, I think that in those cases, I want judges, I mean, and you're right, we do have to get judges to buy in. I don't know how we do
Right.
that.
And
we can make all the recommendations in the world, and we think things should happen a certain way, but if we don't get the judges to buy in, it is a problem.
Sure, and I've thought about that. One of the other ideas I have for getting the judges to buy in, again, you have to have a different judicial disciplinary process, because this one clearly does not work, right? So you're never going to get the judges to buy in if you don't have that. Another thing I would do is allow everybody to record every family court session. They shouldn't be able to disrupt it, but everybody could do it with their iPhone or whatever, and that way there'd be a lot more accountability. A lot of the judges are counting on the fact that, you know, the pro se litigants in particular are just too poor to pay for a transcript, and there's that in my experience, that results in a serious amount of malfeasance.
You got to get by the court reporters lobby on that one. I mean, we can't even share transcripts amongst ourselves, so if I buy a transcript, I can't share it with the other lawyer we are supposed to. So
You've raised a great point, which is one of the things the people of Connecticut have to determine, and what your task force has been tasked to do, is to figure out, are the family laws of Connecticut going to work for the families of Connecticut or the divorce industry? And I define divorce industry to be really big. The phrase I really use is divorce machine, because it just eats up everything that it comes into contact with, including children, and that's sad. So I think you have to change the courthouse schedules, you have to change the union rules so that people have family law hearings on evenings, on weekends. You need to eliminate this entire short calendar nonsense, which from what I can tell is an entirely made-up crisis designed to deter people from access to the court, okay? There needs to be much more oversight of the judicial branch. And that's true with respect to the laws. The vast majority of our family laws in the state, or a lot of them, are actually judicially created laws. There are a whole series of immunities that have been created and handed out like candy to a whole bunch of actors, which, again, economically just breeds malfeasance because people are absolutely unaccountable. There are real reasons to give people immunity in certain circumstances, and I appreciate that. It's way overdone. I think there's been way too much deference even to the administrative issues on the family court system. The fact that that the judges or someone else is picking when the courts are in session and it's not working for families is bad. I think every motion should be tracked. When I was a federal court judge, we had an aging schedule for every single motion. We knew exactly when it was filed. We knew exactly, how long it had been, when the last action was, and we were nervous. We were scared. We wanted to be providing good service because we were afraid people would look down at our judge, which made us look bad.
Right, and we only have tracking for the initial case and not for anything post-judgment, which we've talked about being a problem too.
Sure, and that's a huge issue, and I appreciate how complicated information systems issues are. I do want to say that there also, in my experience, there are real issues of malfeasance within the courthouse. I want to give you one specific example of that. I filed a motion to dismiss my guardian ad litem, or the guardian ad litem for the minor children, okay? And I, although I didn't have standing to bring it, I ultimately got her out. I filed that, I think, in June. That motion never came up for marking on the short calendar. It never, ever came up. Meanwhile, my guardian ad litem, who had had the court appoint her an attorney, someone who was very much a court insider, who I since learned has been named as a defendant in, I think, 4 lawsuits, one of which he is being sued by a former client for soliciting a bribe to an AMC, and that AMC happened to be my ex-wife's attorney at that time. So you would think, wouldn't this person recuse himself? Of course not. Instead, he shows up and he asks for initially $850 an hour when I'm a stay-at-home dad, my wife's on disability, and everybody knows that we're going bankrupt, okay? What does he do? He files a motion. Well, I mean, he's not allowed to file a motion. In the practice book, it says that guardian ad litems can't file a motion. All they can do is fill out a form. They check a box asking for a status conference, and then they can tell the judge what they want. What does he file a motion for? His fees and the fees for the guardian ad litem. What comes up on the short calendar? Not my motion to dismiss the guardian ad litem. It's his motion for fees for him and her. That's interesting.
I read you sent your testimony earlier, and I read it before we came in.
I didn't send any testimony.
You sent a letter or something. You sent something. Are you Mr. Sargent?
I am.
Yeah, you sent something because I read it.
Okay.
Someone sent something with your name on it because I read it. I was surprised. How long has your case been from start to finish to date, or to the time when your GL was removed?
My GL was moved in December.
I don't know when your case started, so if you could was a year, 2 years, 3 years? I filed in April 2012. So a year.
2011, April 2011.
A couple years.
Yeah.
As I just was surprised at the amount that your letter indicated you had paid to that person.
Again, there are absolutely no limits. I will admit my circumstance is particularly complicated, okay, and I understand how difficult these things are. On the other hand, it was expensive because there was, frankly, a lot of malfeasance. And again, it's malfeasance against someone that I may not have a lot of recourse to. If I'm crazy enough to sue a judge and ask for declaratory and injunctive relief, you can be sure I'm going to be crazy enough to sue a guardian ad litem.
And I think you also said you were putting together a briefing document. Was that you?
I don't know what I've said. I've said things to certain people, but I don't think I said anything to the task force.
We received something, and I think
other people, I think, forwarded things to me. But I have spent an enormous amount of time thinking.
Because I was going to ask if you had it. Okay, give it to us.
I am thinking. I do think I have spent an enormous amount of time thinking through the public policy ramifications of this, because I appreciate what an incredibly difficult position that you're in. I think that you've been tasked with kind of a mismatch of issues that don't really belong together. But again, I do think, in contrast to some of the really complicated legal issues I toy with, I could actually figure out how to write a statute that would improve a lot of this. Am I going to have time to do it when I'm a stay-at-home dad for 3 small kids and the pipes were broken at Greens Farms Elementary School on Monday and Tuesday after Friday's snow day? Maybe not. But if I can get it done before I run out of money, then, I'll send it along.
Yeah, I was just trying to find what we were saying, like a briefing, whatever, but we would be happy. I'm sorry. We would be happy to look at it. I'm not saying you should do it. I just was.
Sure, and I'm happy to help you in any way. One of the things I have issues about the composition and the procedures of the panel. I don't think there should be any industry people on the panel, and I don't mean that to be disrespectful to anybody. I think instead it should be families, because the family law system should work for families, and then they should call people like you, because obviously your insight is necessary to determine what's working, what's not working. And I believe that the parents should be doing the talking rather than what I would call the divorce industry. And I don't mean that in a disrespectful way, but it is a business. It's a huge business. And I'm always remiss, because even when members of the divorce industry testify, they tend to get a lot more questions, and I think really it should be the parents. I think we should start with the complaints and the concerns about the parents, and then we should figure out, what are we going to do. So I've taken up way more than my time, and I'm very apologetic for all the people. Yes, ma'am.
I don't know if anyone asked you, because I was in the restroom, but was your GAL an attorney, a mental health professional, or something else?
She purports to be a psychologist.
Thank you.
So big picture-wise, I appreciate that what you're doing is extremely complicated. There are a lot more sophisticated things that can be done in terms of creating a separate ethics board just for members of what I would call the divorce machine. So a parent with a complaint about a judge, a guardian ad litem, anybody else can go to one source, and it gets reviewed in a different way, since the existing system is clearly not working at any level. I think that that's important. I do think, though, the fundamental, most basic change you could make would be to eliminate the entire for-profit guardian ad litem, the private pay guardian ad litem system. Under no circumstances should private individuals be allowed to maximize profits from families in difficult situations at government compunction. That's not okay. I think that there are very, very few limited circumstances where guardian ad litems are even necessary. That's my personal view. I realize they're convenient for judges. I'm making their lives much more complicated. That has to be addressed. That does, right? The judges have an interest in this too, and they're not here, right? So, we need to give them more resources too. That's the unfortunate reality of the situation. Thank you.
I do have a question. I'm sorry.
Yes, ma'am.
Do you think there's any correlation with the influx of self-represented parties and the influx of court-appointed GALs?
They have the common cause, which is basically it's just profit maximizing behavior. So, I was represented by a very sophisticated divorce counsel when I had the money. But like everyone else, even construction workers now would rather represent themselves than pay money. Why? Because pretty soon into it, you realize that your supposed lawyer is not actually representing you. Your supposed lawyer is representing the divorce machine. And they will keep this whole thing going. And, you're not going to get a better result from retaining a lawyer. And that's why people become pro se. Even before they run out of money, they become pro se. It's not rational for you to retain a divorce attorney in this state. That's sad but true. There are a few exceptions to that. But in general, in terms of system-wide, there's just so little accountability for someone who doesn't represent your own interest and instead represents his or her own interest that people become pro se for that reason. The guardian ad litems are there just for the same reason. They're trying to maximize profits. It is the case that judges like a guardian ad litem in a circumstance where both of the parties are pro se. So you're right. Once the parties are pro se, the judge doesn't want to do any work, for real reasons. The judges are overworked. They're busy, right? They have to make a lot of difficult decisions. They probably don't have the resources to handle the docket loads they have right now. So as soon as both parties are pro se, the judges are going to want the GAL, and the judges are going to defer to the GAL all the time. And that's why in 3 years I've had one hearing. Everything else happened at a status conference, right? That's not okay. There's no evidence. There was no notice. There was no nothing. There's no way that comports with due process. It just turns out that you can't necessarily get a federal court judge to tell a state court judge that that's the case because of certain federal preemption doctrines. Okay, so and believe it or not, a state court judge can violate your constitutional rights in a lot of cases without recourse. That's just the truth of the matter. That's sad, but that's true. Mr. Wisemuth.
Yeah, you appeared pro se. Did you find that you were limited in your ability to obtain subpoenas, and did you consider appearing pro hoc vici?
Okay, interesting question. So I actually subpoenaed a lot of people when I was pro se. I spent a lot of time writing my subpoenas. I got them all served. I did it under the most complicated circumstances you can possibly imagine. The problem, though, is you're not going to get the hearing. So when at one point I actually had subpoenaed a large number of people, and people dodged the subpoenas. The guardian ad litem dodged the subpoena. The guardian ad litem for my wife literally dodged the subpoena. She called the process server and said, I'm not going to get served. There's no recourse. And that was rational for them to do, because there's no recourse for me for people who do that kind of thing. Eventually, because I'm a little more sophisticated than the average bear, a lot of these people do business through LLCs. An LLC has to have a representative agent in the state, so I subpoenaed their LLCs in round 2. They can't dodge that, right? So I actually subpoenaed a lot of people, served a lot of subpoenas. I got them all there for the hearing, and my ex's lawyer basically said that I hadn't given notice of expert with respect to certain people and blah, blah, blah. I had. The judge didn't care. The judge just agreed with her. The judge hadn't read anything, right? So, that's the problem, right? That's the problem. There is no rule of law in the state of Connecticut. And so, not to disappoint you, but even if you come up with your perfect legislation, until you get the judges to actually start following the rule of law and start following constitutional rights, and I don't mean to disparage all of the judges, but I'll be honest with you, I haven't come across a good one yet, and I've been in front of a lot of them, and none of them will compare to the federal judges that I had experience with on the Third Circuit. That was an incredibly different level of person. Okay, that's a problem. So I'm very apologetic to the other people for taking too much of their time. Thank you very much.
Thank you, Mr. Sargent.